Hello everybody, it has reached 2 o'clock, which is the start time for this webinar. We're going to give people a few more minutes just to join in. Still got participants. Actually, I think we've now reached over the magic figure of 100, so I think we're ready to make a start. I want to welcome everybody, first of all, to this webinar, which is the latest in the Cornerstone series of lockdown webinars. This one is taking us perhaps forward out of lockdown, looking forward to the future, and looking at some of the consequences of what happened during lockdown. We're looking at the issues of providing accommodation and support to people with irregular immigration status. And as the previous screen said, all the notes will be available after the webinar. On our website, we've got a dedicated coronavirus unit. The video recording will be there available, as are the recordings and notes for previous seminars as well. I'm delighted to introduce to you Peggy Etiebet and Tara O'Leary, two members of Cornerstone Barristers Housing and Community Care teams. And we are doing this as a joint presentation because this is an area of law where people's issues do not fall happily into one little pigeonhole. People have housing issues and care issues, and care in housing and housing in care. And you can't really just pigeonhole somebody and say, this is a housing matter, this is a care act matter. This is an area where people have a holistic set of issues that local authorities need to teamwork on and have some joined up thinking on. We're dealing with the law on this in relation to England alone, not England and Wales, because Wales have their own laws in relation to housing and homelessness in particular. And we're not dealing with Scotland either, because that's a foreign country as far as England and Wales are concerned. So we're going to be covering the issues of being NRPF, no recourse to public funds, and Peg is going to tell you all about what that means. Tara's then going to start on what the Housing Act deals with in relation to eligibility for housing assistance. Peg is going to take over the reins again and talk about the issues under the Care Act, and then Tara will tell you about the Children Act. A key issue at the moment is the Localism Act and the extent to which local authorities can use that. Peggy will be taking you back onto that. And then at the end, we'll be having a little roundup. Questions and answers at the end. We've already got lots of questions that have come in, and they will have been worked into the answers that we're going to give you. But you will see on your screen there is also a Q&A tab, and if you want to ask questions arising out of what Peggy and Tara are talking about, please feel free to do so. I'll keep an eye on those and then ask Tara and Peggy to answer the questions as we go along. At the end of the session, if there are any unanswered questions or any specific questions that you want us to deal with, feel free to pick up the phone, send us an email, send us a brief if you think it's one that needs a bit more of a longer considered answer. But in the meantime, please do feel free to send us any questions that you want us to ask in the course of this session, and we'll do our best to get round to as many of them as possible. So what we're talking about, as I say, is the interface where housing, social care, immigration and politics meet. And it is politics that's been driving this at the moment. And politics is all about people. People have various issues. Some of the people that we have to deal with are foreign people, heavens. And it's nearly 200 years ago that Lord Ellenborough, who was then the Chief Justice, the Lord Chief Justice, said in a case called Rex against the inhabitants of Eastbourne, he said, as to there being no obligation for maintaining poor foreigners before the statutes ascertaining the different methods of acquiring settlements, the law of humanity, which is anterior to all positive laws, obliges us to afford them relief, to save them from starving. So even 200 years ago, Lord Ellenborough, who was a bit of a beast in many ways, thought that there was a duty on a decent society arising out of the law of humanity to help people with who are foreign but starving. Over the last few months, coronavirus has illuminated the impact that being without recourse to public funds and being without the normal routes into assistance have on people. One of the strategies that the government went for straight off as coronavirus started to bite was what we call the everyone in strategy, insisting that local authorities should get everyone off the street. And about 15,000 people have been assisted into temporary accommodation to get them off the streets during that period. And as a result, there have been far fewer deaths, it seems, than we would normally have expected from people who were rough sleeping. And the fact that they've been brought in off the streets, placed into settled accommodation, I'm not using settled in the homeless term, but places where you've got a fixed address where people can come and find you, write to you, that's really helped people get further forward. Now, we're now moving to the end, we're moving towards the stage where lockdown is lifting. What do we do with the people that were helped in off the streets now that hotels want to get back to letting tourists come and stay there? The homelessness minister suggested that people who had been helped under this provision, we should just suggest that they go and live with their family and friends. Gosh, why didn't you think of that, people, before? Don't be homeless, go and live with somebody that can accommodate you. It's simple, isn't it, really, if you're the homelessness minister? It may not quite be that simple in reality, of course. The government, to be fair, has allocated £3.2 million in rough sleeper funding for councils. Another £3.2 billion have been allocated for response to the virus. It's not quite clear to me how much of that is stuff that would have been given anyway. But there is now the rough sleeping COVID-19 task force to find permanent housing for the people brought indoors during the Everyone In strategy. But last Tuesday, 16 local London councils, Southwark, Ealing and Hackney among them, who are some of the ones with the highest numbers of rough sleepers, 15 charities and faith leaders, wrote to the Home Secretary asking them to lift the legal limits on the benefits and housing support people with no recourse to public funds have, because that makes it, to quote, almost impossible to secure long-term homes for many rough sleepers. And the letter goes on to say, as it stands, all restrictions are due to come back into force in the near future, creating a cliff edge beyond which councils will once again be prevented from providing many rough sleepers with the housing and other support they need. The government response to that one has been to say, we've been very clear that nobody should find themselves destitute during this crisis due to circumstances beyond their control. Families with leave under family and human rights routes can apply free of charge to have no recourse to public funds conditions lifted, and we encourage anyone eligible to submit an application. Anyone probably joining in this seminar has got experience of Home Office applications and the speed with which those are dealt with. Perhaps an indication of the approach the government is going to take is that during the passage through Parliament of the domestic violence bill recently, very welcome aspects of that in many responses, but one of the things that the government refused to do was allow women with no recourse to public funds who are domestic violence victims to be able to access the assistance given under that. It seems likely that the hostile environment trailed by Theresa May well carry on in full force under her successor Priti Patel. So we're going to talk about that. What we can't do, of course, is predict the future. We do not have a crystal ball. We can't tell you whether there's going to be a second wave or a resurgence of the pandemic, a second lockdown, and what will happen going forward. But this is how we see things at the moment. And as I say, this is England, it's not Wales, and it's not Scotland, where Scotland has just financed indefinite hotel rooms for rough sleepers. So let's see where we are in England and what we can do to assist local authorities to assist people in need. So I'll start off with the issues of NRPF. What does it mean and who are we talking about? Peggy.
Thank you, Catherine. You'll have seen from the list of things that we were going through that there was a lot here. As Catherine said, housing, social care, Localism Act. There is a lot. I'm not going to be able to take you through every single slide. What I'm going to try to do in my sections is to bring out either key learning points or to try and answer some of the queries that have come in prior to today, to bring out the learning points that way. So as Tara, or I think as Catherine may have mentioned at the beginning, you will get the slides and you will get the recording, so the information will be there. I may not just address it directly today. Right, so my first point, learning point, is who exactly do you mean by no recourse to public funds? It's a big, big bugbear of mine. You can hear the irritation in my voice, that people use this term really loosely. They use it as a catch-all for anyone regular status whose immigration status may preclude them from some sort of welfare support. And the difficulty is that if we're looking to see what to do now in the future, how to help these people that we brought in, or how to help the new people that are knocking on our doors, or local authority doors, for support, we need to know exactly what their immigration status is. So just to remind you, no recourse to public funds are people who have a grant of leave to enter. They may be here on a 36-month visa, they're allowed to work here, but attached to that visa, they have a condition that they have no recourse to public funds. So that's who they are. Give me the next slide, please. I set out there the legislative framework, but we can jump to the next, please. And set out there just to highlight to you, or when you're helping your client departments understand, or particularly your councillors, because as Catherine says, it's a hot political issue, the councillors are well involved in it, that it doesn't apply to EEA nationals or EU nationals who are exercising a right to reside. That's the legislative background there. And I think the last slide in this section, Catherine, is what are the public funds that people with this condition are not entitled to. So they're not entitled to housing under Part 6 and 7, and Tara will deal with that in detail later. But importantly, they're not entitled to welfare benefits, or child benefit, housing tax benefits, sorry, council tax benefit, housing tax benefit, child tax benefit. And so the problem is, as you well know, the cases we get across our desks, single moms, young child, working hard, low paid job, probably as a carer, they simply can't afford all the necessities of life, and so they're coming looking for assistance. The last line there, or penultimate line, discretionary payment under, thanks Catherine, under the Localism Act is really important, because as we'll see later, I think some of the local authorities may have thought that they were assisting no recourse to public funds persons under the Localism Act. That is a public fund as defined by immigration rules, so there may be difficulties there. Thanks, Catherine. Moving on to Schedule 3 of the National Immigration and Asylum Act 2002, what I want to get you to get from this at the end of it is to see that there's certain categories of persons, or certain classes of persons that we can deal with according to their immigration status. So we've got the no recourse to public funds that we've just dealt with. We've got subject to immigration control that Tara will generally deal with. We've got those who are caught by Schedule 3 of the National Immigration and Asylum Act. And then we also have the fairly new one, those that fall within the EU settlement scheme. They've got pre-settled status, settled status, or they're here on a family permit. What do we do with those? So those are the 4 main categories we're looking at. Schedule 3, you all know what this is. They are what prohibit local authorities from providing certain class of support to a certain class of persons. And I need you guys to all note the formulation of this. Sorry, I thought I was talking to my water polo children there. I need you all to note the formulation. So it's a negative thing. You cannot do it. You're precluded from doing it, unless you make a decision that you can positively do it in a limited exception. So precluded from doing it unless there's a small exception. And it's part of what Catherine referred to earlier as the very hostile environments Theresa May brought in. Next slide, please. Who does it apply to? It's set out there at paragraphs 4 and 7A of Schedule 3, but the main ones you'll be dealing with are EEA nationals and then those in the UK who require leave to remain but don't have it and are not an asylum seeker. So cases that I get are perhaps an individual, they've been here for 5 years, so they've got permanent residency, they've now ceased to work for whatever reason, they may become old, injured, had a stroke, and they're now looking for Care Act support. How do you help them? Those who require leave to enter or remain do not have it. Maybe someone who came over here on a visitor's visa has now overstayed, got pregnant while they were here. What do you do in that situation? So that's who was caught. What provisions are included? Again, there's a whole long list of them at paragraph 1, but the common ones, section 17, Tara is going to be dealing with that. Leaving care provisions, we've left those out of this talk only because they are a very niche area. So we can address those in email or by briefs. But I'm going to concentrate on the Localism Act myself, and then the Care Act and what supports you can give to peoples under those two provisions. Right, what type of supports? Again, the learning point here is that you cannot, or a local authority cannot provide accommodation and subsistence support. And I've concentrated on that because all the queries we've been getting are that how can we accommodate? How can we support these persons who we brought in and now may have to put back on the street? So accommodation is what we're looking at, the main thing. Local authorities cannot provide accommodation under those provisions, the Care Act, the Localism Act, if the person is not otherwise eligible for that support and that type of support under the applicable legislation. So you'll all know you'll have to do your Care Act assessment first. You'll have to assess whether you're allowed to give that support under the Localism Act. Thanks, Catherine. Yeah, so effectively, I'm just giving an example there, looking at the second bullet point. If it's under the Care Act, your Care Act assessment would have to have decided that this individual needed their needs for care and support to be met by way of accommodation, and that accommodation had to be a necessary and appropriate conduit for the practical and effective delivery of care and support for the looked after needs. I'll deal with that in more detail in the later section. That comes from a case that Catherine, so shout out to her, Catherine, was involved in, the Aburas case. Very useful case to read because it sets out in detail the summary and the history of this area. Right, so the limited exception is the paragraph 3 exception. This is that you may provide support, so you've got discretion there, where and to the extent that the exercise of the power of performance of the duty is necessary for the purpose of avoiding a breach of convention rights, that's the human rights or rights under the EU treaty. So I've repeated there that the support can only be of a type that they're eligible for. And I keep on repeating that because some of the pushback I may get from a client department or pushback that I may get from an applicant lawyer is that, well, they are destitute. They have crossed the threshold because you've done your Human Rights Act and you may not be able to return to the country of origin, so therefore they should be entitled to accommodation and support. And what we will see from the Aburas case is that that's not correct. One needs to look at the needs for care and attention, so needs for care and support, and whether, and through using that prism, whether accommodation is a requirement to prevent a breach. But I'll deal with that later. Thanks, Catherine. Right, so you must make the decision. So that's the framework that we're talking about. You're precluded from doing so unless you make the decision by way of your human rights assessment. And a lot of the difficulty I'm finding in the cases that we have at the moment is that if a local authority believed that they may have been accommodating someone under the Care Act as taking into account this exception, there's no human rights decision to validate or to evidence that. So you must have a positive decision. Right, so the convention rights you're looking at when you're doing your Human Rights Act assessment, Article 8, that's an obvious one. Article 3, the right not to be subjected to inhuman or degrading treatment. We got a query in on this, and it was effectively how much in the human rights assessment do we have to look into the incidence of COVID in the country of return? My lawyer's answer is it depends. But the framework in which you're assessing that is going to be that
they're saying when they return to the country of origin, they are at risk of ill health. They may not be able to access appropriate care. This is an Article 3 right. We know what the case law relating to that is. There's the new case in the Supreme Court of, I think it's AM and Zimbabwe, which effectively says that you must be, and I've written it down because I don't know it offhand, you must be, it's no longer the old test, remember, that you're at imminent risk of dying, i.e. you would be dead if you went abroad. It's now a real risk on account of a lack of appropriate treatment or lack of access to treatment, which would lead to a serious, rapid and irreversible decline in your state of health, resulting in intense suffering or significant reduction in life expectancy. So still a fairly high threshold, but not as high as before. But the key for your human rights assessment is that it's for the individual to raise a prima facie case of Article 3, and then for you to assess that. And generally speaking, if there's no Article 3 asylum application in, then that may be a very good guide that the Article 3 claim is not one such as to breach the threshold. So in your human rights assessment, you can be satisfied that there will be no Article 3 breach on return. But it is something that you probably ought to address in most cases. If it's a 25-year-old who's otherwise healthy and they don't raise it, no. If it's someone who's 57 with, has just gone through chemotherapy and is immunosuppressed, yes, look at it. So that's the, it depends. And then the other one, sorry, Catherine, I just want to talk about that fourth bullet point, the Article 6 right to a fair trial, because that also leads from another question. And the question was whether, well, it was some family courts are, some family courts are asking, directing, persuading local authorities to provide accommodation subsistence to special guardians in care proceedings, where they have no recourse to public funds, and they were saying, do we have to do that? And so I just wanted to raise that one of the relevant convention rights in your human rights assessment is a right to a fair trial. That includes procedural requirements to being there, to having access to the evidence, to be able to cross-examine. And so you would need to have to assess in each individual case whether, if they were to return to their country of origin, they would be able to have a right to a fair trial. So it's something that you have to look at. Thanks, Catherine. We can jump now. So that's just a summary slide. If you make a decision you can return, then should the applicant choose to remain in the UK, there's no breach of the convention or EU rights. I highlight this one because it's hard. It's very hard. You've made a decision, the local authority has made a decision that the person can return to their country of origin. In the vast and overwhelming majority of cases, this doesn't happen. So your social worker knows that this person is going to disappear into the gray area, and they're like, well, what do we do? And I just need to point out that if they choose to remain here, then there is no breach, and although it's a very hard case to determine, then you cannot lawfully assist them. And that's the case of AR and Hammersmith. You are precluded from doing so. Oh, and then last on this, practical barrier to return. So you'll be aware when you undertake your human rights assessment, you're looking at whether there's a legal or practical impediment to return. COVID-19 travel restrictions were an absolute barrier to return. I've used, it's a case-by-case basis. For example, I did a case with Nigeria. They had repatriation flights that were in existence that cost money. You had to go into quarantine for 2 weeks thereafter and pay again for that. It all cost money. But I said to the local authority, well, if you're coming to this decision and you have to consider whether there's a practical barrier, if you decide to make it, if you make a decision to pay for that repatriation flight and the quarantine at the other end, then there no longer is a barrier. So you have to think outside the box sometimes to get around COVID-19 travel restrictions. I think that's it. Thank you, Catherine.
Thank you, Peggy. Good afternoon to everyone. I've seen that there are lots of names on the list today who are, I think, repeat visitors to our seminar. So I'm delighted so many of you are coming back for more punishment. And I'm starting to think we're going to have difficulty finishing at 3 o'clock for this one. So fingers crossed you're all finding this useful. I'm going to briefly talk about the Housing Act 1996 just for a couple of minutes, and there'll be lots I can't cover. In terms of what ineligibility or eligibility actually means within the context of the 1996 Act, we could do a whole training, which would probably also take much longer than an hour, just on that and on the ins and outs of immigration rules. I can't cover that here. All I really want to bring to your attention is the rule which incorporates eligibility into the 96 Act is section 185, which doesn't itself actually tell you very much about who is and isn't eligible, because what it does is it essentially incorporates by reference various other categories which are set out elsewhere, particularly by the 1996 and 1971 Immigration Acts. But what I can tell you is that Chapter 7 of the Homelessness Code of Guidance is actually very helpful on this, and it provides a fairly useful summary of who is and isn't included in a way that's quite helpful. It's not the length of a book, it's just a few pages, and you should be able to look through it fairly quickly. Now, eligibility generally, I'm seeing a message from someone saying we seem to be hearing a beep or tone. I don't know if that's coming from me. Perhaps Peggy, if you might mute your microphone. And you can all tell me if it's carrying on or you can't hear me because of it. In most cases, the homelessness team are not going to be the ones who have to actually make the decision on eligibility. It's going to be pretty clear, you know, whether someone is or isn't eligible, and it's for them, obviously, if you're in doubt, to provide you with proof of whatever status they've been granted by the Home Office. Section 185 says that two categories of people are ineligible. They're both defined as persons from abroad. The first is persons subject to immigration control. Very headline summary is that they are people who require leave to enter or remain in the UK. But I want to bring your attention to the 2006 regulations, because from a homelessness perspective, this is really the main source that you're going to need to go to. Those regulations set out a list of people who are exempt from this rule. Thank you, Harriet, who's told me you can hear me. And I am sorry, I don't know where that beeping is coming from, but I'll look into it once I finish this section. The 2006 regulation set out people who are exempt from this exclusion. It's all phrased quite negatively and is a bit confusing in that sense, but it sets out a list of people, in particular refugees who've actually been granted asylum on successful applications, and people who've been granted leave to remain who are not subject to the NRPF condition. So pretty self-explanatory. They can have recourse to public funds. The other category of people who are excluded are other persons from abroad. Now, they're not subject to immigration control, but the same 2006 regulations exclude them from assistance. The main one you need to worry about there is actually category A, who are people who are not habitually resident. And I highlight that because that is, I think, one of the only categories where the local authority may have to make an assessment themselves about habitual residents rather than the Home Office. Essentially, you're going to be concerned with people who are dividing their time between the UK and another country, and you're going to need to decide effectively whether or not they have a permanent resolution to reside here. I think in the context of coronavirus, potentially you might come across some people who were in the country visiting earlier this year and who effectively got stuck here, and you might conclude they're not habitually resident. The others are people who are EEA nationals, particularly with very limited rights. So they're only here as job seekers, have only been here for less than 3 months, or they are parents or carers of British citizens, so they themselves are ineligible. Their children or people they care for are eligible. You need to have a look at Regulation 6 of the 2006 regulations. And again, that sets out a class of people exempt from the habitual residence test. And the relevant thing there that you need to know is that a worker from another EU country is eligible, basically. So if you're from another EU state and you've got a job, you're in. Now, I've written an article a couple of weeks ago about which of the powers under the 96 Act can be used to assist ineligible persons. And we also discussed this during a homelessness during the pandemic webinar we did a few weeks ago. So you can look those up on our website if you'd like to know more. I think there are 6 powers that you can definitely use to assist ineligible persons. The first is your general power to provide interim accommodation under section 188. So that is a case where you may have reason to believe that A is eligible. Now, I've given you the reference to paragraph 15 of the Code Guidance and the Kelly case. they both suggest that the threshold for having reason to believe is very low. You don't need to be satisfied the person's eligible. If you think they might be in priority need as well, then your duty to provide interim accommodation is engaged. And then secondly, you can see below that if you issue your section 184 decision saying, we're very sorry, but we think or conclude you are ineligible, and they want to challenge that, there's a discretion to continue accommodating pending a section 202 review. I would say it's probably most relevant there that if someone has made an application to change their status to the Home Office or has a pending immigration appeal, those might be fairly compelling grounds upon which you should consider whether or not to extend accommodation to them and to postpone effectively either your 184 or 202 decision until that's resolved. On the next slide, paragraph 4 I think is quite important because, yeah, so we have this slide with paragraph 4 is taken from the code guidance where when you terminate section 188 interim accommodation, you can extend the notice period for the termination of that accommodation effectively without limit. I've seen some cases lately, not eligibility cases, but other cases where the local authority issued a section 184 decision saying we're not in priority need, but we're going to continue accommodating you until further notice because of the pandemic, and just simply left it at that. And they've kept their rough sleepers in whatever accommodation that they're in. I think that's perfectly lawful. I think there might be some tricky questions down the road when you eventually come to terminate the notice, and you just need to give cogent reasons for why you now think it's fair and reasonable to move them on. But I think that's important, and I think that does give you a great degree of flexibility, even when you think someone may or may not be eligible. Paragraph 5 is also very important because anybody, regardless of eligibility, has the right to be provided with information and advice regarding homelessness. And I think you can construe that local authorities are entitled, if they wish, to construe that duty very broadly, potentially to signpost people towards remedies in immigration law or to assistance from local organisations who might help them make applications, for example, to the Home Office to lift their NPRF condition. And so I think that's also one where you might want to, well, local authorities could certainly exercise a discretion to be creative in how they do that. And then finally, number 6 is the limited duty to what are called restricted cases. Now, this is a case where somebody is eligible and they approach the local authority and make an application for housing assistance. But the only reason they are found to be in priority need is by virtue of another family member who is ineligible. So a disabled child or parent or someone in the family that they can reasonably be expected to live with. If you come across a case like that, then you can accept the main duty to them, but you can only discharge it by way of a private rented offer. Very quickly, I think Peggy already mentioned that there is provision for someone to apply to the Home Office to lift their NPRF condition from their right to remain in the UK. I'm sure everyone on this seminar, and I don't think we have anyone here from the Home Office, so all of us would agree that those decisions are not always dealt with as efficiently as we would like. But you should be aware of this recent decision in the case of W from just a couple of months ago, which effectively ruled that the Home Office's entire regime for deciding these cases was unlawful, and issued a direction requiring that officers be given proper instructions about the fact that the Home Office has a duty to lift that condition or to refuse to impose it in the first place if there is fairly cogent evidence that somebody is going to be at imminent risk of destitution if the condition's not lifted. It will probably surprise no one to hear the Home Office was not accepting those applications. The general thinking is that hopefully this decision should make those applications proceed a bit more fairly. I think it's beyond dispute, probably quite large numbers of NPRF households will now qualify those applications because they were previously working and supporting themselves. They're now out of work because of the pandemic. And again, I would just say that if someone has made that application, regardless of whether or not it has been processed or determined, but they are able to provide a local authority evidence of that, the local authority would have to take that into account in any decision about whether or not to extend interim accommodation. I won't say what they should decide, but it's certainly a material factor. So I've listed this list of questions. I don't think in the time available I can answer them, but these are the sorts of questions the local authorities are going to have to consider in the next, well, beginning now. When do you terminate accommodation? Where do you move people onto? What is a reasonable period of notice? And then I think also the question of whether or not, even if you're going to stop accommodating, you might be able to provide ineligible persons with deposits or loans of a few months' rent so they can get a placement in the PRS. I think particularly for people who had been supporting themselves, fell into difficulty during the pandemic, but are back in work in due course, that's going to be really important, and it's linked directly to the Localism Act. So that's why Peggy's going to answer that question later rather than me now. But certainly I think a case-by-case decision-making on these points is going to be important, and I would not recommend that any local authority decide that as of the 1st of September, they're now not accommodating rough sleepers anymore. I think what you need to do is look at each case individually and take into account people's facts and circumstances. And that applies in ineligible cases as well as in any others. On to Peggy.
Thank you, Tara. So I just removed the chat from my screen. Right, Care Act, can you use it to provide accommodation? The key point for me would your local authority want to use it to provide accommodation? We know that the aim of the Care Act is not to provide general accommodation, a whole host of case law on that, the most recent being Catherine's case of Aburas. I put the quote there, but effectively it says that the Care Act is for meeting needs for care and support, the Housing Acts are for meeting needs for accommodation, and the two really should not meet. The reason I ask you to ask the people behind you or who are pushing for innovative ways in which local authorities may assist these class of persons is that any wider, looser, more generous interpretation of your powers and your duties under the Care Act are going to apply not just to these very, very hard cases we're dealing with at the moment that have been highlighted by COVID, but the general raft of cases you get. So the one I always mention is you're going to have, or you'll have seen the case of, for example, a disabled person, 10th floor flat, living in very, very poor circumstances. They can't get out, so they're micro living. It's a breach of their Article 8 rights. They want accommodation, bare accommodation that's not residential care or anything like that. And if you extend it for this class of persons, what's the principal reason that you're not going to have to extend it or apply it for another class of persons? So these questions as to whether you can accommodate under the Care Act, under the Localism Act, cannot just be seen in isolation. And the judge in the Aburas case effectively set out why. Thanks, Catherine. I think there I've just repeated what I said before. You must be eligible under the Care Act, and you must do that, undertake a Care Act needs assessment, and it must be a proper one. I've seen some that not very good, but you must do a proper needs assessment. Thanks, Catherine. Great. So one point I want to pick out is when you're doing your Care Act assessment, you must look at Section 19 power. We are generally so focused on the Section 18 duty, so you must meet needs for care and support where there's assessed eligible needs, where there's 2 or more outcomes that have a significant effect on well-being. But what the Aburas case made clear is that the Section 19 power to meet needs, and you will know that meeting needs for care and support is the same as being looked after in the SLAU terms. So it's a very wide or fluid definition. If you just need looking after, you'll have a need for care and support. The Section 19 is to be read as imposing a duty to secure your convention right in applicable case. So always in your Care Act assessments, you look at Section 18 needs, assessed eligible needs, as well as Section 19 needs for care and support. So the big question, can accommodation be provided under the Care Act? So not just for the sake of it, you must have a need for care and support as well. I'll read out the second bullet point because it's very useful. So the need for care and support has to arise from their physical or mental impairment or illness, and not just because they don't have accommodation. So it's not a standalone need for subsistence or accommodation, and that's the case of AR, Hammersmith and Fulham. So one question that came along earlier was in relation to asylum seekers who had chosen to return from their areas of disbursement or not taken up their Home Office accommodation in a dispersed area because they wanted to remain in the London borough, and they stayed with family and friends. Due to COVID, situation became critical and they've effectively been asked to leave. What do you do in relation to them? Can we accommodate them under the the Care Act. And so the answer effectively, unless they have needs for care and supports that require the provision of accommodation to facilitate the meeting of those needs, you cannot do that. Thanks, Catherine. And so that this is the test you have to apply. Always useful to stick it in your Care Act assessment to show that your decision maker has addressed their mind to the proper test. Accommodation may only be provided where it's a necessary and appropriate conduit for the practical and effective, that should read, delivery of care and support for the relevant and looked after needs. So you may have a need for prompting with your medication. Do you need accommodation to be prompted with your accommodation? With your medication? The answer in a certain circumstance could be yes. Another one, it could be no, because the PA or whoever's prompting you could come to wherever you are, or you could go to the, well, in pre-COVID times, you could go to the office and be prompted. There are other ways and means of doing it, not just by the provision of accommodation. Thanks, Catherine. And then, so the additional question that you have to ask yourself is that, because remember, we're dealing with people here, or considering people here who are caught by Schedule 3, so you're excluded from helping them unless it's needed to meet a breach of their convention right. And the test for considering whether it's a breach of the convention right is set out in the Aburas case. And it makes clear that a high threshold is whether there's an imminent prospect of a serious suffering caused or materially aggravated by the refusal to provide accommodation so as to secure the support to meet the relevant needs. And the context or the factual framework behind that was that the request was for accommodation. So as soon as they showed they had a need for care and support, accommodation ought to follow. And the judge was saying, no, one has to look at the need for care and support itself and view the breach or the potential breach of a human right through that prism. So in the example I gave earlier, if the person doesn't have access to their medication, is there, as a result of them not taking that medication, an imminent prospect of serious suffering caused by that? And one could reach a, when it's very reasonable view, that no, there is not. And so that's why I say that the exception test can be a high one once one applies that very nuanced understanding that has been teased out by Catherine in the Aburas case. Thanks, Catherine, for both things. And then I just want to point out there, of course, the section 21 exclusion. So you can't meet needs for care and support where they've arisen solely because the adult is destitute or because of the physical effects of being destitute. And again, I've just put that there, I highlighted there, because one of the questions we received was in relation to persons who had no needs for care and support because they were in accommodation at the moment, but it was anticipated that as soon as they were out of accommodation, then they would be vulnerable and need support. And it was, what was the situation there? So I just wanted to bring that section to your attention, because one has to distinguish between needs for care and support and where the need has just arisen because of destitution. And this last slide is, what do you do now? So you've accommodated them and you're looking to, what's the next stage? And it's just echoing what Tara said, is that unfortunately, you're going to have to look at each case you have. I know that each local authority is going to have hundreds of individual people that they need to assess on an individual merits basis. But you're going to have to look before you cease whether they have needs for care and support, if those needs for care and support require the provision of accommodation, and if so, when they're caught by Schedule 3, whether they pass the breach of their convention rights threshold before you can cease support, because of course, you cannot cease support without an assessment, and that's what is required here, because if you don't do it, then what you're very likely to face is pre-action letter, injunction, and you're going to have to do it. It's a lot of work, but it's got to be done. Thank you.
Peggy, there's a question that's come in as to carrying out Care Act assessments. When you're not a unitary authority, if you are an authority that doesn't have Care Act obligations, can you? Sorry, did you get that, Peggy?
I think I read it. You muted out. So I think.
Sorry.
If you're not a unitary authority, can you take a Care Act assessment? The question is, I would have to ask you why you would want to. So you have a duty to do it if you're a county council or a district council that has no county council in your area. That's the duty. You presumably would like to do it because you've disagreed with what your district council's solution is and you believe that it's an unlawful assessment, or they've applied case law wrongly, or they've taken an extraordinarily robust view such that it's outside the range of reasonable responses. My general approach in those circumstances would be to sit down with the applicants, to provide them with some advice and assistance, saying these are the areas in which, you know, the assessment could be relooked at. Perhaps you go back to them and ask them to relook at it, concentrating on these areas 1, 2, 3, 4, or you signpost them to the local CAB or legal aid solicitors for assistance. If you did the Care Act assessment, nothing stopping you from doing it, it would have no legal weight, as it were. It's just a comparison document. So I wouldn't go to the trouble.
Thank you. Let's go back to Tara for the Children Act then.
Great. I don't mean to jump around too much, but I did see a really interesting question from Robin Levitt, that what I'm getting from Peggy is that there's no legal way for a borough to operate and everyone in policy. Is that a fair assessment? I think I feel personally so frustrated by this that I sort of want to jump on the answer a little bit, which is the government creating the hostile environment and excluding thousands of people by law from assistance, and then telling local authorities one morning in March that they needed to do everything possible to accommodate people without giving them any legal powers to do so. I mean, I'd like to think that there's maybe some political accountability for that. I'm not really sure that there is. At least there's funding, which is something. But I think the reality is that all of the different sections of this presentation today, unfortunately, what we're doing is illustrating an ever dwindling number of boxes that we hope people could fit into. You know, there's a sort of a Venn diagram which gets narrower and narrower and narrower as the powers you can use to assist ineligible people. And so I think what we're just trying to do is not, there is no legislative change. There's been no new rules brought in to facilitate the everyone in policy. But there are things that can be done, and I think it's important to understand them and to understand how to exercise them, and then potentially in due course how to transition away from them and make lawful decisions about what happens next. When it comes to the Children Act 1989, I think that's a great example, because like Peggy said, in the Care Act context, there has to be a separate assessment of need carried out by someone who is not a housing authority or a housing team. And I think the Children Act is exactly the same. There will be certain cases where families with children might be able to get some assistance under Section 17 of the 1989 Act. But we'll see, Schedule 3 also applies. So there's actually quite a lot of people who are excluded even from that assistance. And what you end up with is the narrower category of potentially a fallback of protecting people's convention rights, which is a much narrower form of assistance. The slide that we're looking at, I don't think anything here is news to anybody. There's a general duty to safeguard and promote the welfare of children. But that duty is not, it's a target duty, which means you don't actually have to achieve those aims. It will not be the case that every child in need gets everything they need to ameliorate those needs, if that's not a clumsy way of putting it. So it's not an absolute or specific duty owed to children in need. On the next slide, what I wanted to highlight was that there is a limited duty, and this might pick up on the question that was asked about unitary authorities. The Housing Act 96 does provide a limited duty to effectively cooperate and make referrals between housing services and social services and vice versa. It's Section 213A. If a housing authority makes a decision that someone's ineligible or they're going to refuse the main duty to them because, for example, they're intentionally homeless, they need to alert social services with the applicant's permission. And then vice versa, a social services is entitled to request assistance and support from the housing team, potentially in saying, well, you know, what's happening with the 202 review, or maybe potentially helping them to find a physical property which could be used to accommodate. It's pretty well established now, the Barnett case 2003, a child without accommodation is a child in need, and Section 17 can be used to fill the breach for families who have nowhere to live. But I think the really important thing here is firstly, it's a children's services assessment. It's not something really that the housing team can make that assessment for themselves. Secondly, if the applicant is unhappy with what's being offered or not being offered to meet their children's needs, their means of addressing that is by way of judicial review against the Children's Act assessment. And then I think just a point that I do want to draw out is the fact that not every child who is without accommodation will be given accommodation under Section 17. Very large numbers of children will be sofa surfing or staying somewhere temporarily with their parents. Now, they will not necessarily be given their own home using Section 17 powers. Very often it would be lawful for Children's Services to say, well, they've got a roof over their head for the time being, they're all right for the moment. Just to highlight, for those of you who are from housing teams wondering what, if anything, you can do to help under the Children Act, this is not the same as a suitability assessment, and the principles from Enzalo Meso and Westminster don't really apply. And so put those details out of your head, as it were, if you're dealing with this area. Next slide, we can see that Section 3 does apply to assistance that can be given under the Children Act. There are regulations from 2002 which set out what help can be given to Schedule 3 families under the Children Act. It's very limited. It's generally, if you're about to return to your country of origin, they'll give you some accommodation for days or weeks until your flight takes off effectively. That period might have become extended over the last few months, but it's not a long-term form of support. And so that leaves us with the fallback on protection of human rights. The relevant case on that is on the next slide, and it's the case of Clue. And the Court of Appeal set out a series of questions that the local authority should ask itself if it's considering providing Section 17 support in order to prevent or remedy a breach of the applicant or their children's human rights. What is their immigration status? Are they, first of all, in breach of immigration law? So we're looking usually at someone who's an overstayer or an illegal immigrant. They're not an asylum seeker. Are they in fact destitute? And if a local authority is not satisfied with the evidence of that because family are helping them out, they won't qualify. Is there any impediment to them returning to their country of origin? If it's only money, social services can step in. I think coronavirus clearly may well have become engaged for a lot of people there, meant they couldn't fly or travel. And then the next question is does the applicant enjoy Article 8 rights in the UK? So they've not just been here for a few weeks, they have established rights. And would a return to the home country impede those rights? The last 2 points are important because the facts of Clue were that the local authority refused to provide any support, notwithstanding that the applicant in that case had a pending immigration appeal. And so that's something that can be relevant. The local authority shouldn't be assessing for itself the merits of that application unless it's plainly hopeless or an abusive process. You should probably wait for the Home Office to make its decision, and you should take it into account in deciding whether or not somebody would completely lose their ability to have a meaningful appeal or to have their application determined if they were summarily returned to their country of origin. That might be a factor which weighs in terms of supporting them to stay here a little bit longer. I picked out a couple of cases that I think are probably relevant to human rights assessments in the Children Act context at the moment. The first is this case of Conde from 2005. There's EU nationals who, she had come from Spain as a job seeker. She was looking for a job. She asked for support to maintain herself and her kids. And it was ruled that it was perfectly lawful for the local authority to refuse support on the basis that she could go back home to Spain. Now, I think that's important because it does show that somebody who is from another country outside the EU might actually have slightly better rights than an EU worker in that respect if they have immigration appeals pending, whereas an EU job seeker will effectively not, Section 17 is not there to help them find a job in the UK. They can go back and enjoy their Article 8 rights at home. Obviously, if borders are closed because of coronavirus, that would have changed that assessment, but it might be relevant otherwise. Secondly is, I think this might also come up where, really it's only the parent or the primary carer of a child who is going to be given Section 17 support. There's 2 cases where it was like a cousin who said she wanted to live in the household. And then the more recent case of OA in Bexley was one where there was an older child aged, I think only about 19, and said that the subsistence provided to the family needed to be enough to supply mum, younger child and older child. And it was held that no, that wasn't the case. There's no particular reason why very often an older sibling or extended family will all need to live together. And then finally, the Nigeria case again is just be very careful about refusing support if it might mean someone is deprived of their right to an appeal. That's it. It is, I've just seen the comment. I'm afraid, I think the buzzing is with my computer because the fan in the laptop is running. So I'm afraid I can't reset it or turn it off without going offline for a while, but hopefully you can hear me.
Sorry, I couldn't unmute myself. I was just looking at Robin's question again. I completely agree with everything before I get into the Localism Act, with everything Tara said. And I just wanted to draw everyone's attention to what Luke Hall said, our minister, relevant minister, said on the, and I'm giving you the details so you can Google it. On the 11th of May 2020, he gave evidence before the Housing, Communities and Local Government Committee. And essentially, he was asked, was it a difficult decision that the central government made to fund accommodation for those without recourse to public funds? And I was telling the others, when you read it, you can see the panic coming out of him. And his answer was essentially, and he repeated it like 3 times, there has been no change in the legal background relating to persons, legal framework, sorry, relating to persons with no recourse to public funds. He repeated that about 3 times. And he also repeated that we may have given, I'm reading between the lines here, we may have given local authorities funding, we may have asked them to bring everyone in, but those decisions were for local authorities and it was for them to make it lawfully. So he shifts the responsibility onto local authorities. So it's for local authorities to satisfy yourself that what you continue to do from now on has a legal basis. And there may be some scope in the Localism Act if you wish to do it. And we'll go on to that now. Sorry, I want to get rid of the question function so I can see the slides. Right, Localism Act, can you provide accommodation under it? The answer at the moment is no. Oh wait, sorry, before we get onto that, before we get onto the good bits, you can't provide accommodation under the Localism Act if you're not otherwise eligible for that type of support. To figure out whether you are, we go to sections 1 and 2. Section 1 of the Act says you've got the power to do anything individuals may generally do, but section 2 limits that, precludes you, forbids you from doing so if you're limited by a relevant pre or post commencement limitation. So the question we have to ask ourselves is, when we're looking at accommodation and support, is there a relevant pre or post commencement limitation? Thank you, Catherine. And what we know from the AR and Hammersmith case is that no, you cannot provide accommodation under the Localism Act because there is a relevant pre-commencement limitation, and that is put in place by section 185 of the Housing Act. And effectively the judge was saying there that that precludes local authorities as a whole, in a holistic fashion, providing accommodation to those with irregular immigration status. And so that is the limitation that applies. It's right to say that this is only a first instance decision. So there may be scope there if one wished to pursue it, but it's a fairly robust decision. Right, Localism Act, can you pay for accommodation? Can you give it an individual fund so they go off and get their accommodation themselves? That was left undecided in AR and Hammersmith. The judge did one of those things that was like, oh, this is a really good point, but no one's made any submissions on it, so I want to address it. He gave indications that it was unlikely. And one of the indications he gave is referred to in the second bullet point there, the Cannes case, Court of Appeal case. This is 2004, so it dealt with the situation under the vaguely similar 1948 Act, National Assistance Act 1948. And what the Court of Appeal said there is difficult to believe that Parliament intended to prohibit the direct provision of accommodation to persons like Mrs. Cannes, but not to prohibit its indirect provision by the giving of financial assistance for the securing of such accommodation. So no case law on it. There is a gap there, there is a lacuna there. If one is looking for innovative solutions, that's a possible area we can go into. But again, I take you back to that question beforehand. Do you want to do it? Do you want to do it because is the point of the Localism Act to provide an alternative route to housing, or would that be circumventing the point of the Housing Acts and the eligibility criteria under that? So yeah, exactly. Thanks, Catherine. That's The next slide. So did Parliament intend for it to be used to circumvent or override a clear statutory scheme which prohibits people with irregular immigration status from accessing subsistence support, or in the example I was just talking about was in accessing funds for accommodation? If we go back, Catherine, if you would please, because the question I'm asking there is, can you make subsistence payments under the Localism Act? The answer is it's unclear, mainly because there's no case law on it. My view is that there's no act that prohibits it, so we'd be hard pressed to find a pre or a relevant pre or post limitation. And it's consistent with the Can case, where in the Can case, in very similar circumstances, they said payments can be used for other stuff. In that case, it was closed, but here it could be subsistence payments. So there is more scope there for a subsistent payments to be made under the Localism Act. As I say, no case law on it, so it is an area that local authorities may wish to look deeper into if that's what they're going to do. But those would be subsistence payments, not payments for accommodation. And then I just wanted to re-highlight the point I made at the very beginning. If you're subject to a no recourse for public funds condition, you're excluded from a discretionary payment under the Localism Act, as it's classed as a public fund. There may be an argument, is it a discretionary payment if you're forced to make it because of the breach of an Article 8 right, which has converted it into a duty? We can argue there, but these are all difficult questions, not been litigated, and we'll all be happy to to advise you further. Again, to point out in the Localism Act, it is one of the sections in Schedule 3. So if you're individual, if the person before you is caught by Schedule 3, then it remains subject to Schedule 3, paragraph 3. So you can't use it in an individual case unless you've done the Human Rights Act, and it's necessary to avoid a breach of convention and/or EU rights. And I think that brings me on to the point in the next slide, Catherine. Yes, what do you do now? So questions I'm getting is that we accommodated people under Section 1 of the Localism Act. What do we do now? My question back to you is that, okay, so you've told me that's what you're doing. What basis did you do it? Did you do it because everyone was in a panic in March, you wanted to get people in and you just did it, and you didn't really think about what the basis was? If that's the case, and you've now turned your mind to it, determined or satisfied yourself that there is no way in which you can do it, then if you're legally precluded from doing it, you can cease it on that basis, because there can be no legitimate expectation for something that's unlawful to do. But if you are one of the local authorities who wish to perhaps expand and make wider the support that you can give under the Localism Act, so for example, see if one can provide support for accommodation, funds for accommodation under the Localism Act, if you were, then you can continue supporting. I've asked the question, do you need to undertake a human rights assessment? So again, in lots of these cases, I think I said at the very beginning, no human rights assessment had been taken to make that positive decision. So to stop ceasing support, if you did it under the Localism Act and you want to continue to do it, you're going to have to undertake a human rights assessment to evidence your decision either way. And then again, at the last bullet point there, I just put in the risk assessment for the implications in other areas, because what we have not mentioned yet here is funding. How the local authorities consider they're going to be funding these accommodation under the Localism Act or under the CARE Act, if that's what they're looking at. I was asked one question as to whether local authorities have been giving a grant for, I think it's track and trace, whether they can use that to support people with irregular immigration status with accommodation. And my response, and this is just a general response, is that the grant of funding by central government does not make lawful what is otherwise unlawful. So even though government says, here's some money, do spend it on this, you must make sure that you can lawfully spend it on that. Then the second subsidiary question is, if the purpose of that grant is track and trace, if it's ring fenced for a specific purpose, can you lawfully use it for another purpose? And for that, we would have to look at the specific conditions upon which that specific grant has been used. I've also come across this problem in relation to, or this issue rather, in relation to the monies central government gave to CCGs to help with hospital discharges. So lots of local authorities were using them to facilitate quick hospital discharges, or in fact to facilitate people not going to hospital, to accommodate them, to prevent that. And they had irregular immigration status. And again, it was whether those monies could be used in that way. And I think my response there again was, it must be lawful in the first place. And in the second place is, can you actually use those CCG monies in that way? It takes a lot of working through, but it's dubious. Thank you.
Shall we pause a second and look at some of the questions that have just come in? One of the questions is GS and Camden. Somebody answered that one while we're off screen. In AR and Hammersmith, and also in Aburas, the judges thought that it was probably not correctly decided, but it is, I think, very much restricted to its own specific facts. We had a lady there who was in extreme need. What else have we got? The advice from DHCLG was that we rely on Section 1 of the Localism Act 2011. And my comment to that is, nobody's going to challenge you if you do something under Section 1. It's if you refuse to do something under Section 1 that you're likely to get a challenge. But then, as Peggy said, it's if you stop doing something under Section 1 of the Localism Act that you really have got to think about what you were doing and what records you've done as to why you were doing it. Let's just deal with this question of pregnant women with no Care Act need, overstayers, no other children. What's the best route to help women in those circumstances? What do you think, ladies?
First of all, you have to think of Section 19 power. So one will be hard pressed. I accept just pregnancy is not a need for care and support, but you're going to be hard pressed to find a pregnant woman where the effects of that pregnancy on her may not mean that she needs to be looked after in some way. So you have to be very careful that there's no Section 19 type needs. And then the next point is that under the Children's Act, you can undertake assessments before the baby's born. So how pregnant is this woman? If she's 8 months pregnant, the baby's imminently going to be born, then your Section 17 duty is going to kick in, and you're going to have to provide accommodation at least at some stage when the baby's born. So you have to be looking at that. Is it worth fighting for those 3 or 4 months in between when she's 3 months pregnant to when she's 8 months pregnant? So you have to weigh up the cost-benefit analysis, as it were. They're very, very difficult cases. And generally, if there's a legal or practical impediment to return to the country of origin, then you're going to be, a local authority is going to be accommodating. It's a very poor optical case for a local authority, a woman with an unborn baby being on the street.
You've also got to think about the practicalities of return, where the seatbelt on the airline won't actually go around her pregnant belly. That's one reason for difficulty in returning.
Can I just to say that the powers I outlined under the Housing Act 96 would also apply to her, which are limited. But for example, if she's appealing her decision, or there's any doubt about her eligibility status, then everything I discussed also applies to her.
So we've already gone over the 1 hour that we said this was going to take, but we have got a few more slides left to go, and I think they are pretty interesting, so I do hope you can hang around a bit longer. And we're going to go on to, first of all, the question of right to rent, which is one of the more tricky questions we've got. Which one of you is doing that one?
That's me. I'm not going to spend long on this at all. The save is to just point out that the right to rent exists. It's a thing. And looking at this slide, it's important to bear in mind, I think, first of all, that it only applies, the second point, to people who do not have valid leave to enter or remain in the UK. Almost always, that is someone who is overstayed a visa or entered without a visa. You can see in the third point, the vast majority of people who might be ineligible for support under the Housing Act are still entitled to rent. The question is actually whether or not they can afford it because they don't qualify for housing benefit. So I think that's important to remember. And the reason these rules are so controversial is, of course, because landlords themselves don't understand that distinction and are just simply refusing to rent to people like myself with strange foreign accents without actually necessarily delving into the background checks. On the next slide, you can see a few more points about this, because this will be relevant to local authorities who are thinking about helping people get their own placements in the PRS to resolve their homelessness. You need to look at the Immigration Act 2014. I've just flagged the recent Court of Appeal decision from April, because last year there was quite a shock decision where the High Court ruled that the scheme, the right to rent scheme, was discriminatory, and essentially struck it down and said it was unlawful. And the Court of Appeal overturned that quite recently and said it should stand. So as things stand, it still applies. I suspect it's almost inevitably destined for the Supreme Court next year. There's been no suspension of the right to rent under coronavirus. There's simply some government guidance for landlords which talks about how they can check and confirm people's documents. But I think the important point is the final one, section 21, subsection 3, says that the Home Office can exercise a discretion, granting people who would otherwise not have right to rent, granting them permission to do so. Now, usually, and I've highlighted the word usually because I link there to some guidance from July 2019, which is called Home Office Guidance, a short guide on the right to rent. I couldn't fit the name on the slide, but setting out the circumstances in which permission will be granted. And again, it's usually there's a pending appeal, exceptional circumstances, and protection of convention rights. The assurances to that effect that that is the Home Office policy were also sent into the High Court in the case of Stewart, which is a case that Peggy was involved in. And it was all to do with whether or not you could refuse assistance under Section 17 of the Children Act, because they could apply, amongst other reasons, they could apply for permission to rent. And so again, I think similar to applying to lift your NRPF condition, that's something that's available to people, and probably larger numbers of people this year than was the case in the past, and might, at least on a temporary basis for 6 months or so, be something that a local authority could consider in order helping people to get into their own accommodation.
Yes, this is me. Section 4 support. I've just put that there because there were some queries that referred to it. And so I just wanted to make clear that Section 4 only applies to failed asylum seekers, not just general NRPF. So you must be a failed asylum seeker. And if you are, and you're precluded from maybe other type of support, the local authority can signpost you to Section 4. And the test there is the same. It's where the provision of accommodation is necessary to avoid a breach of a person's convention rights. The way in which it might be delivered to an individual is more difficult. It might be dispersed. You want to get it through vouchers, etc. And so it's less attractive, but it is an option to rely on. And it was mentioned in the Aburas case. And it's a difficult one to meet effectively. And then thank you. And then the Coronavirus Act, there was lots of references to this, but there's nothing I can see in the Coronavirus Act 2002 that empowers you, local authorities, to provide accommodation and support to persons with irregular immigration status. I think that's what Tara and Catherine were saying about the spin that might have been put on things, but there isn't. And then the derogation. This was a couple of questions from a couple of local authorities. So that's been applied in London boroughs and a few neighbouring ones since I think September. It's now from I forget when exactly from, but it's applied nationally up until the end of December. And what this is, for those that don't know, is that Article 24 is for equal treatment. So we ought to be applying equal treatment or equal access to services for EU nationals. There is a derogation from that, and a country doesn't have to allow persons to have equal access in specific areas, one of which is access to welfare support. But what the government has done is derogated from that, but only in a very tiny circumscribed fashion. So it applies to EEA nationals for non-statutory homelessness services, such as hostels and any advice and support they need to remain in accommodation and then move on to other accommodation. So it's not been removed for normal homelessness and housing support, only for non-statutory services. And also it's meant to be only for a 3-month or 12-week period for each individual. So I don't know how the central government expects that to work for any individuals that need it for longer, whether you're meant to cease support at that stage or not, but that is there, and that will help local authorities accommodate and support EEA nationals, rough sleepers.
Thank you very much, Peggy. Children from NRPF families do have the right to free school meals at the moment, so there is that. And just a few more questions and answers that have come in. The status of a lot of people we've housed is unclear. If subsequently they can be brought into funds, what then? Was it potentially unlawful to support them under localism until their status is established? Well, as I said earlier, I think act under the Localism Act, nobody's going to challenge you. It's when you terminate your decisions that you've got a problem. So there's one slide that I always put up in every lecture that I give, which is keep records, show your workings now, show what you're trying to think about now. Everything has got to be done on a case-by-case basis. You can't have any broad brush, one-size-fits-all criteria. You've just got to think about what the situation is in every case. One question I wanted to ask, and this one's for you, Peggy, who is the burden of proof on when it comes to considering destitution? Is it up to the person saying that they're destitute to show that they will be destitute unless helped by the Home Office, or for the Home Office to prove that they won't be?
So you referred to Home Office. Can I answer in relation to local authorities?
Of course, yes. Yeah.
It's a tricky question, only because some judges say it's in relation to the local authority that should prove it. The approach that I always take is a local authority has to be satisfied as to whether an applicant is destitute. And so in order to be satisfied, they need evidence and information on that from the individual. If the individual chooses not to cooperate or not to provide the evidence, to provide conflicting or inconsistent evidence, then because of those reasons, the local authority can be satisfied that there is none. So I tend to say, no real burden of proof. It's an investigatory type of exercise. Let's all work together to find it out so we can be satisfied as to whether there is destitution. But you do need help from the individual. Don't know if that's the approach that you take, Catherine.
And how does that fit in with the request to the Home Office to decide whether or not to impose an NRPF condition in the first place? Who's the burden of proof on at that point?
Well, that...
Can the local authority help the person apply to the Home Office for that condition to be lifted?
Oh, they can certainly help in that they can write a letter saying we have, looked into the circumstances, we have accepted that they're destitute, we are supporting them in the interim on the basis of destitution, so there you go. And one would hope that the local authority, the Home Office wouldn't look behind that. But I mean, you may correct me if I'm wrong, the Home Office always tends to put the burden on the applicants, but I would have to look through that. I don't know the answer to that.
Okay, I think the questions that we're now getting are very specific ones that we're not going to be able to answer in a way that's going to be helpful, generally speaking, and we are now 20 minutes over our allotted time. So unless there's anything else that you two want to mention at this point, no, I'm going to say thank you to everybody for attending. Do feel free to send in further questions to the email addresses, which are, if I get my screen working again, right at the end. So sorry about this.
They'll be on our website. They'll be on our website in due course.
Yeah. Yeah, I hope you've enjoyed today's session and that you found it useful. Thank you all for attending, and we hope to see you again in future webinars.